in the bench were able to tell for a fact, based upon the law that, that guided the determination of this dispute, it was most likely that he will invalidate this decision. And it don't come as a surprise that 3 other judges toed the line with him in coming to that conclusion.
All right. And of course, many had said in the run-up to this verdict that the schools of thought that the different judges of the bench come from would at the end determine the final verdict of this. Let's take a look on page 4 and 5 of the Standard newspaper there. So we have pictures of the bench led by Chief Justice David Maraga. As lawyers, you would, of course, you know, having understood some of the cases that he has handled, some of the rulings that he has given. So we saw that Justice Njoki Ndung'u and we had Jackson Ojwang there having dissenting opinions. But in your view, Oliver, did the school of thoughts of these different judges then, at the end of the day, mean, you know, come to this verdict that they gave?
It is a yes and a no. I think if you take, for example, for Maraga, he has built a firm jurisprudential base over time. For him, I expected a decision which could not have departed so much from what he has been holding on all those other matters previously. But of course, I expected Njoki to dissent. She has been the one dissenting in the Supreme Court mostly, although albeit with very good and cogent reasons. And for Lenaola also, very good analysis of facts and law in most of his matters. He has always analyzed matters in a way to broaden the scope. And it will be remembered that when he was in the Constitutional Division, he did a tremendous job. And that is what earned him a position in the East African Court. So for him also, it is always, you expect a judgment that is, it will go for centuries.
Right.
And then we have also smoking, the smoking gun. Deep. He is always very deep in terms of the law and in terms of the jurisprudence that emanates from his deduction of the matters. So for the three, I expected something very strong. And that's what I'm looking forward to read their full text after 21 days. It will be interesting.
20 days from now, have it.
Well, I do not think really it's a matter of the school of thought, because the clarity with which the principles for determination of invalidity or validity of an election of the president is one that can be borrowed or mirrored on the determination of the validity of an election of member of the National Assembly. And look, if you see some of those judges who gave the majority decision, these are judges who have handled many of these petitions. I think the only disappointment on the dissenting minority will be in respect of Justice Professor J.B. Ojwang, because he's been a High Court judge, he's been a professor of law for a long period of time. For Njoki Ndung'u, I don't think it's a school of thought. I think that is just a political affiliation. And the story was already ripe in the grapevine. There is no way she will rule in favor of Raila Odinga being a stalwart of the Jubilee administration.
All right.
Now, the disappointment that I see on the part of Professor J.B. Ojwang is an accomplished scholar. And look, there is no school of thought that can be discerned from the manner in which his dissenting decision was made. It is most likely that these camps were just affiliated. And look at it from a historical point of view, right from